Buenos días, buenos días a toda nuestra audiencia. Es un gusto saludarlos hoy en nuestro segundo día de esta tercera cumbre de negocios estrechando lazos comerciales entre África y Latinoamérica. El día de ayer ha sido un día demasiado interesante donde aprendimos ese trabajo que ha venido desarrollando el gobierno nacional con el continente, cuáles son las características de la agenda para los próximos 4 años, cuáles son los principales temas de cooperación internacional que se vienen trabajando con diferentes gobiernos de este continente. Y por la noche tuvimos la oportunidad de mirar esas perspectivas desde Latinoamérica. Contamos con la participación del señor Vladimir Pimentel desde República Dominicana, quien nos comentaba sobre su participación en una misión comercial, especialmente en Ghana y en Nigeria, y la experiencia de Anthony Canvas en Angola y ese trabajo que ha hecho en facilitación del comercio y las aduanas en este país. Hoy, en nuestro segundo día, vamos a hablar la importancia de la política de competencia y esto cómo está afectando esta nueva integración regional que África está teniendo mediante lo que nosotros conocemos como el Acuerdo Continental Africano, en inglés el AFTA. Y para este tema tenemos una invitada muy especial, a la señora Bela Kedogo. Ella hoy nos saluda desde eh, Guinea. eh, Está participando justamente en un evento respecto al tema y ella nos va a explicar cómo funciona el tema de política, cómo funciona política de competencia, por qué es importante hablar de estos temas y esto cómo impacta la forma en hacer negocios y obviamente la atracción de inversión extranjera directa sobre el continente africano. Esta conversación va a ser en inglés, entonces en este sentido, pues vamos a hacer voy a hacer el switch de idioma y pues nada, bienvenidos a todos, espero que tengan un buen día y comenzamos nuestra primera sesión del día. So, ladies and gentlemen, it's a pleasure to have you here for us and from the University Fundación Universitaria San Mateo. It's a pleasure to have you here, Mrs. Bela Kedogo, to share your experience and your knowledge about trade policy, trade competition policy, and doing business in Africa. I know that this is going to be like an interesting topic for all of us in order to know more about to know more about how to do business, yeah, and how the competition policy like it's important, yeah, to develop this new kind of investment, business, export, import, and other related areas. So it's a pleasure to have you here, Mrs. Bella. Thanks for your participation. I know that you were in another forum this morning finishing, and it was like kind of hard internet connection, but thanks very much to take your time in your agenda to get the participation with us. Welcome to Colombia digitally. Welcome to Latin America, and welcome. So I will share my screen. Um, 1 second. So I just want to know, I'm going to share my screen. But first, I would like to introduce 1 second. Oh my God. But first, I want to introduce Mrs. Bella. Mrs. Bella have more than 10 years doing different kind of research. Um, 1 second. Okay, I have here. Okay, Mrs. Bella have more than 10 years of experience doing research. Now she's doctor in philosophy and in computational law from the Technical University of Munich. And right now, she's been working with the UNTAC as a research partnership platform. And right now, she's a visiting fellow of the University of Cambridge, working on a project on the limits and potential of competition law in protecting gig workers' right collective bargaining. So, Mrs. Bella, it's a pleasure to have you here and welcome from Bogota.
Okay, thank you so much for Christian for inviting me to discuss about the potential of competition law in enhancing trade in Africa, especially in the recently established African Continental Free Trade Area, which brings on board 55 countries and which has created a larger market, a continental market that is made up of more than 1.2 billion people, and which we hope that it will not only increase the inter-regional trade in Africa, but also interregional, and it will open opportunities for businesses outside Africa to come and invest in Africa and tap some of the untapped sectors in the African region. So I do believe that trade and competition law complement each other, whereby competition law tries to ensure that businesses or firms participating in a market have the same playing field, and some firms are not taking advantage of the market to engage in anti-competitive conduct like market allocation, exclusive dealing, or predatory pricing, creating barriers for firms to enter the market. And therefore, the first thing I'm going to do is to give you status of competition law development in Africa. And therefore, with this, we are going to understand how our businesses are able to work together with competition agencies. So if you could move to the next slide. So the status of competition law in Africa is that before 1990s, it was considered to be the last continent to have adopted competition law, which is very true because only three African countries had a competition law in place, that is Kenya, South Africa, and Gabon. But in the 1990s, the World Bank pushed some of the African countries to adopt competition laws, World Bank and IMF, as Africans were trying to change their regulatory systems. But but now, as we speak now, the development and adoption of competition law in Africa has occurred in three levels: at the national level, at the regional level, and at the continental level. Next slide. So we have seen that out of the 55 countries, more than 41 African countries by 2020 had adopted competition laws. And we have Burundi now has a competition law, and they're now working towards operationalizing their competition agency. And then we have countries like South Africa, Senegal, Zambia, Zimbabwe that have the most established and oldest competition regimes in Africa. Next slide. So this is how the landscape is as 2020. This is a paper that we wrote with Professor Tim Butte. If you Google it, it's on the spread of competition law in Africa, a research agenda, whereby we did a preliminary review of how many countries have competition laws, what are some of the research questions that we should be looking at, what are some of the challenges that the African competition regions are facing, like establishing the competition agencies. Some of them, they did adopt competition laws as early as the 1990s, but up to now, they have not been able to start enforcing their competition laws and so on. So that is just how the status looks like. So next slide. So as a business, you have to really understand and know which countries have competition laws, which countries have mandatory merger regimes, so that when you are engaging in a merger transaction and you want to expand into the African continent, which of the competition agencies you need to file your mergers with, what is the merger filing fees, and what is the merger threshold. So this is one of the map that shows you that when you look at the southern part of Africa, you see that there's a small country in South Africa called Lesotho that doesn't have a competition law. But all these other African countries, when you see the dark red color, these are countries that have a competition law and also have an operational national competition agency. And then you see the other colors. By 2020, DRC did not have had a competition law, but they did not have a competition agency. But now they do have a competition agency, so you have to really understand what is their law, what does it say. When you look at the East African side, you see Tanzania, Kenya, Ethiopia by 2020 had a competition law and agency, but then in 2021 they disbanded their competition agency. So currently they don't have a competition agency, but they're trying to have a department under their Ministry of Trade. And then when you look at the West African side, you find that there's a number of countries that have competition law, like Nigeria recently, but Ghana does not have a competition law, but they're in the process of adopting a competition law. And also, if I go back to the eastern side, you see like Uganda by 2020 didn't have a competition law, but now they have a competition law and they will have a department under their Ministry of Trade. So that is how it looks like. So the next slide. So the next slide talks about the dispute resolution mechanisms. So if you had, if let's say a competition agency made a decision regarding cartel conduct or an investigation they did, and you'd like to appeal, so African competition agencies also have tribunals. In Kenya, we have the competition tribunal. Zimbabwe has a competition tribunals, and most of them they have cartel conduct prohibition, they have mergers. Some of them have voluntary merger regime whereby you don't need to really notify the commission, the competition agency, but the commission agency can require you to file if they realize later that your merger transaction has an anti-competitive issues. And then most some of the African competition agencies also consumer protection and provisions. So next slide. So in addition to the national competition agencies, we also have the regional competition agencies. And Africa is one of the continents that has the most regional competition agencies. It has 7 of them, but 2 of them are what I call in my recent paper, which if you Google it, it talks about supranational cooperation, institution design under the FCFTA, whereby I've been able to show which competition agencies have a cooperative model, which ones have a supranational model. So in Africa, we have 7 of them, and 2, that is the South African development the SADC and SACU, South African Customs Union and South African Development Corporation. For them, they have a cooperation model, so you don't need to file with the institution they have. The institution they have at the regional level only provides a platform for cooperation for all the national competition agencies. But then you have to understand that when you come to COMESA, which is the common market for Eastern and Southern Africa, which has the largest membership, 21 members, it has a special institution akin to the EU Commission. So for the Commercial Commission Commission, you have to file mergers with them if they are meeting a regional dimension. And a regional dimension simply means that your merger transaction is affecting 2 or more COMESA member states, and it's meeting the threshold that has been set under the COMESA competition regulation. And then we have the Central African Monetary Union, we have the East African Community Competition Authority, we have the ECOWAS, which is also for the West African countries, and then we also have the West African Monetary Union, that is why. So next slide, just to see how the supervisory institutions look like. So maybe if you enlarge, there's a number of complexity, especially for business, and I'm going to talk in detail at the end of it, why this is very important to understand. So you want to operate in countries in Southern Africa or Eastern Africa, and you realize that at the regional level, these countries are members of 2 regional economic communities that have a supranational authority. That means that if you are going to file your mergers, you have to notify one of them, because for all of this they have the mandatory merger regimes. So when you look at the western side is a bit complicated. You look at ECOWAS. ECOWAS is the economic community for the West African countries. But within ECOWAS, we have the Anglophone and we have the Francophone. So the Francophone have the West African Monetary Union, that is the YM. They have their own competition agencies. And then the other part of now the entire ECOWAS also has a competition agency. But there's a difference between the institutional design. So when you look at the West African Monetary Union, they have a centralized regime whereby national competition agencies are not allowed to enforce the community competition law. So there's no sharing of competences between them. For instance, under the West African Monetary Union, YM competition laws, the Community Competition Commission um, investigates state aid issues. That if that one falls under the community law, the national competition agencies cannot investigate state aid. And then the ECOWAS, which also is part, all the wine countries are part of ECOWAS. It has a mandate, it has a decentralized institutional design whereby the competition agencies under ECOWAS, which means YM agencies also fall under ECOWAS, they share competences with the ECOWAS. So because ECOWAS started in 2020, is still putting in place its operations. We don't know how it's going to happen in practice, but we are looking forward to that. So when we come to the East African side, we are having the East African community. We are having countries that members of East African community like Kenya, Uganda, are also members of COMESA. So for you as a business person, there's a possibility of having having forum shopping or multiple merger notification in two regional competition regions. But we are going to discuss later how this is going to work in practice and the strategies that have been put in place to ensure that we have a one-stop shop for all this. So next slide, please. So I think to the national competition agencies. So when you look at the regional competition agencies, for example, under YM, the legislation that regulates competition within the YM is the Dakar Treaty, and Dakar Treaty Article 89 and 90, and then we have the 2002 regulation, and then for COMESA, we have the COMESA Treaty under Article 55, and then we have the 2004 COMESA Constitution regulation that you should be aware of. And then CEMAC, they have the 1999 regulations, and for the East African Community, they have the 2006 East African Competition Act, and for ECOWAS, they have the 2008 ECOWAS competition rules. And then the institutions, which are also supranational, they make binding decision. So we have the Wine Competition Commission, the Competition Commission in Ilongwe, Malawi, the CEMAC, the East African Competition Authority is located in Tanzania, and the ECOWAS Regional Competition Authority is located in Gambia. So you look at it, you find that when you look at the substantive provisions for YM, CEMAC, East African, and ECOWAS, they all regulate state aid. It's from COMESA. And then most of them regulate consumer protection, and most of them also deal with mergers and self-conduct. Let's move to the next slide. So here, so now you see, we are having the national competition agencies where you have to understand their powers. We are having the regional competition authorities, they also have to understand their powers, the relation of powers between the NCS and the regional competition regions. When do you file your mergers with the NCS? When do you file your mergers with the regional competition regions? That means in whichever side of Africa you want to do your investment, you have to understand the peculiarities of each competition region. And now here we have the second regulatory institution, the FCFTA competition regime. So African countries have established a free trade area, which is now the African Continental Free Trade Area, which started, I think, in 20 trade under the FCSA, I think in like 2021. And in addition to this protocol, to the FCFTA agreement, it was realized that it's very important to include a competition provision So there's a paper I've written on cooperation and competition policy under the FCFTA. Is available online, especially in Subject, published by the Manchester Journal of International Economic Law, that gives you a deep understanding of how cooperation under the FCFTA in competition policy is going to happen. So initially there was a question of whether, because we already have all these regional competition agencies, whether we should also have competition authority at the continental level. And when the competition, the FCFTA competition protocol was drafted early this year, they have established a competition authority, which will now be known as the FCFTA Competition Authority. So as a business person, now we are having 3 competition regimes that will be able to regulate your conduct as a business person under the African continent. So the FCFTA competition protocol has established a decentralized supranational institutional design, like COMESA, like ECOWAS, and like the East African community, whereby it's going to share its power among the regional competition authorities and also the national competition agencies. So how is this going to work? They also have the board, they have an investigative body, and they also have a tribunal. Maybe we should move to the next slide. So far it has not entered into force. We are looking forward to African countries ratifying the protocol for it to enter into force. And this will be in accordance with Article 23.2 and 23.4 of the FCFTA agreement. So far it has not entered into force. So unlike the COMESA Commission regulations where they entered into force when the COMESA Commission, when COMESA did publish it in the gazettements, but here we are looking forward to seeing whether African countries will be able to ratify the FCFTA competition. Next slide. So this is where now I was talking about the primacy of the FCFTA competition protocol. When does the FCFTA competition authority invoke the decision? So it says under Article 3, and the FCFTA is going to regulate mergers, cartel conduct, and digital markets. So you realize that most of the NCAs and the regional competition authorities have not included the regulation of digital markets in their legislation, which I think some of them are now reviewing the legislation to for digital markets. But FCFTA and Article 14 of the FCFTA competition protocol is going to regulate digital markets. So firms that are going to engage in self-preferencing, steering provisions, parity clauses that are justified, and differentiated treatment between international platforms and digital platforms on the African continent are going to be subject to the FCFTA competition protocol. And then we also have the merger transaction and have the cartel conduct. But the FCFTA competition authority will not have jurisdiction on matters that have a domestic effect. That is according to Article 3. It shall not apply to matters falling within the respective jurisdiction of the national competition authorities. And when it comes to regional competition authorities, that is where we are having some confusion. I hope once the FCFTA competition protocol enters into force, we shall have an interpretation on this, because it says that when there's a conflict between the provision of this protocol and regional agreements on competition law, the provisions of this protocol shall prevail. So we are not sure if you are having your merger and you are not sure whether to file with the Commercial Commission and with the FCFTA Competition Authority. That means that you'll have to get advisory opinion from the FCFTA Competition Authority on where to file your merger. So the next slide. So this is all. So for the FCFTA competition authority, they have jurisdiction to matters that have continental dimension. For the regional competition authorities, it's for all matters that have a regional dimension. So continental dimension in this case, it means that it will be any conduct, any practice, any practice, merger, or agreement that has a significant effect on competition in a market of at least two state parties. But then those two state parties are not supposed to share the same jurisdiction with existing regional economic communities. So if these two state parties are part of the East African community, it simply means that you have to file your mergers with the East African Community Competition Authority. So your merger does not fall under the African Competition Authority. Next slide so that we can move to the main discussion. So how the allocation of competences will occur, we know very well in practice. And for those who have been following the EU Commission decision, the Commercial Commission decision, and even in Latin America, it should be the Andean community, Mercosur, and so on, you realize that even when there's a clear delineation of power on paper, for instance, there's merger thresholds, and if a merger does not meet that merger threshold, it has to fall within this a specific institution. In practice, sometimes it's very difficult to determine because sometimes member states have an interest in a specific merger. Maybe it's affecting a national interest. Let's say it's about arms, or it's about a sector that is very pertinent for that specific country. And in this case, the question that usually arises is which of the authorities is the most appropriate to deal with this specific merger. So these are some of the things that the African Competition Authority will look into. And all I'm saying that they have to have a clear merger threshold, which they have not adopted so far. They have to have a referral mechanism. We have seen cases whereby in COMESA they fall under the Commercial Competition Commission, but because the National Competition Agency is the most appropriate to deal with this, they refer it back to the National Competition Authority. And the next thing I always say that the equitable distribution of benefits. When we are having regional or continental competition authorities, the question of distribution of benefits becomes very important because supernational institutions test losers and gainers. For instance, when it comes to merger transactions, the merger filing fees at the national level reduces when a regional competition authority takes merger. So the ability for competition authorities to be able to have a clear mechanism to redistribute these benefits is very important for the business community, because if we are having a mandatory merger regime at the national level and we are having it at the regional level and we are having it at the continental level and every institution is invoking jurisdiction, it's not good for the business because filing mergers involves legal representation of the business firms have to pay, the lawyers, you have to pay the merger filing fees, and all this only increases the cost of doing business. So next. Let's try this one.
Excuse me, excuse me, excuse me. Uh,
Did you guys lose me because of
yeah,
internet?
so we were here. No, this is the last one. Article 3. This is the last one. There are only 14 slides.
Yeah, that's the last slide. So I want now to go to the question for this. This is just the status of competition law in Africa so that you have a background and understanding on how this is going to impact trade and how to benefit from this and some of the challenges that you are going to when trading in Africa as you interact with all. Okay.
Okay, okay, Mrs. Bella. Thanks for the introduction for what is the real meaning of the competition policy and how it's going to work under the FDA. We understand that like there are already some accomplishments depending on the regional implementation, but the competition policy under the AFTA is going to make like a new big impact in all the continent. Yes.
Mm-hmm. Yeah.
So
So I
well,
wanted to talk
and
about
as
the
you,
next issue.
yeah, yeah, you're going to talk about. Excuse me.
Maybe you can stop sharing so that we could the discussion. I want now to talk about how this is going to affect the business community.
Okay, perfect. You can continue with your presentation.
Maybe in few minutes. So what does this say about doing business in the FCFTA? So
Excuse me, Mrs. Bella. Mrs. Bella, you get froze. Nosotros tenemos una conexión con nuestro ponente desde Gambia, el continente africano. Tiene un inconveniente con su internet. Estamos tratando. Sí, se le cayó el internet. No sé. Oh. Un segundo. Bueno, mientras nuestra ponente se logra conectar de nuevo y supera su conexión con internet, lo que ella nos estaba comentando era la importancia de la política de competencia en los negocios y obviamente pues cómo va a ser la adopción de esta a través de el nuevo acuerdo que ellos están firmando, el Acuerdo Continental de Libre Comercio Africano, que pues es una que se denomina como tal, como un mega acuerdo. Um, Justamente nos hablaba de, bueno, eh, identificaba que a principios de los principios, hace 30 años aproximadamente, estos temas de política de competencia que manejan temas y controlan aspectos importantes en comercio como la protección al consumidor, el tema de carteles, el tema de monopolios, el tema de la libre competencia como tal en el comercio, pues obviamente esté debidamente bajo un ambiente claro y legal. Y nos decía, hace 30 años esto no era algo que se hablara en el continente y nos hacía cómo ha evolucionado a través de los diferentes acuerdos de integración regional. Ya justamente Vladimir ayer nos comentaba los diferentes acuerdos de integración regional. Ella hacía relación, por ejemplo, algunos como el COMESA, dependiendo de la región de África que estamos, y posteriormente, como con el AFTA que entra en vigencia a partir del 2021 de manera gradual, iba a entrar como esta nueva institución o nueva esta ente y cómo esto se iba a poner en margen con las actuales políticas de competencia que tenía cada uno de los temas regionales, ¿no? Destacaba también que hay una parte importante que recoge también la experiencia que algunos de de estos temas ya habían sido tratados y pues obviamente fortalece todos estos temas. Y pues obviamente en pro de mejorar el comercio, la estabilidad para los temas de inversión extranjera, atracción de nuevos negocios y la apertura que se espera que poco a poco pues África está haciendo cada vez más hacia el mundo. Entonces eran de los aspectos como más importantes que podemos destacar en materia de la presentación de la señora Vela. Estamos 2 minutos, estamos mirando si la señora Vela se puede conectar de nuevo. Estamos comunicando, tenemos comunicación con ella por interno, pero nos dice que eh, previamente ya nos había comentado de unos problemas de conexión que se presentaban, donde se encuentra justamente en estos momentos participando en un evento en materia a nivel regional. Vamos a parecer la situación. Démosle. Nos dice que le demos 2 minutos. A ver si logra ubicarse en un espacio donde tenga acceso de nuevo a internet. Tu, 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 tu. No sé si Siris. No, tenemos 2 minutos más a ver si logramos retomar de una mejor manera una comunicación con la señora Vela. Mm, estamos. Tengo- Bueno, al parecer la señora Vela no se ha podido establecer de nuevo en un lugar y tenemos algunos inconvenientes con, con su conexión a Internet. En este momento, desde donde se encuentra, en un evento justamente hablando sobre política de la competencia y negocios en África. Em, pues bueno, yo creo que dadas las circunstancias y los temas tecnológicos y el esfuerzo que ella está haciendo para podernos acompañar, justamente también como ponente en otro evento de importancia continental para África, pues, eh, pues, no sé, ya, pues yo creo que con esta pequeña introducción al concepto de política de la competencia y su relevancia en materia en la agenda que lleva África 2060 y el trabajo continuo que están haciendo como continente para dar apertura al mundo, podemos ir cerrando la sesión de hoy. Ha sido un completo gusto acompañarlos. Lastimosamente, estos temas tecnológicos pasan y pues obviamente los esperamos esta noche en la Fundación sede Posgrados de la Fundación Universitaria San Mateo para seguir hablando de negocios con África, para seguir mirando esas oportunidades que tenemos y más aún para entender cuál es el legado de África en nuestro país. Tendremos una conversación supremamente interesante de ese legado en temas culturales, en temas de lengua y en tema de otros ritos que aunque no creamos, compartimos con África y como nuestros expositores previos han dicho, guardamos una semejanza cultural demasiado interesante y más de lo que nosotros creamos. Entonces, esta noche nos acompañará la señora Angélica Herrera, quien nos dará esos tips importantes de cómo deberíamos desarrollar negocios en economías y en países emergentes enfocados a los temas de África. Y posteriormente tendremos esta actividad cultural que nos trae back, que de seguro será de atención e interés para todos ustedes. ¿Listo? Entonces, de nuevo, mil disculpas por los inconvenientes tecnológicos. Esperamos poder tener otro espacio con la señora Pela en su agenda para que nos termine de hacer esa introducción y esa contextualización de la importancia de estos temas en el comercio con este continente. No siendo más, muchísimas gracias a ustedes y nos vemos esta noche para el cierre de nuestro evento. Entonces, muchísimas gracias.